And the theory here is that there were two or more different subject matters in the same initiative, so that voters could not possibly tease apart what they were voting on. So there were multiple subject matters, and voters weren't voting on one clear thing. And so an Alameda County judge decided to strike this down as unconstitutional and said, listen, the voters didn't have a clear, decision here. I'm gonna enjoin this, and I'm gonna strike it down. And doing so froze the whole situation again, and threw this all back into chaos. So we're back kind of in the soup. And that's an interesting position to be in. Again, when you have 10 million people who voted to sort of set a new balance. As a constitutional lawyer, I sort of wonder how a judge can set aside the democratic will of 10 million people. We have all sorts of ballot initiatives. If you look at California history, where there's multiple subjects, and if you read even one set of ballot initiatives from any election, they're paragraphs long, right? Every ballot initiative, you go into the California voting group, you look at it. I've done this just as somebody who's interested in the subject matter. Each of the ballot initiatives is paragraphs long, right? At times, right? So the idea that this particular ballot initiative has more than one subject, and that's the reason it's unconstitutional, strikes me as a little bit of a reach from a legal standpoint as justification. But that's the principal reason that this judge has paused implementation of Proposition 22.
It was interesting when that case went out, everyone kind of rushed and said, well, wasn't there a severability clause? Like if one section was deemed unconstitutional, like that section would go out and, the rest would be whole. And we kind of went back, and it did have a severability clause, but notwithstanding that severability clause, I guess kind of what you're saying was because the single subject rule was violated, the court said, the whole thing's amiss. Is that right?
Yeah, and how unusual, lawyer to lawyer, right? That the severability, that the judge didn't preserve, the rest of the proposition, right? And only strike down the very narrow section that, in this case, the judge felt was, unconstitutional, and preserve the rest of it, right? Like sever off that piece, keep the rest, and preserve the will of the voter, right? That could have been divined around it, but struck the whole thing down. Really kind of an unusual and exceptional decision by a judge.
Make sure you click the button below and subscribe, and hit that notification bell so you can keep up with all our news and updates.
Are called dreamers.